And good morning to everyone out there. Actually, on my screen, I see a few faces, but not everyone. So good morning to you. And this morning, we are going to talk about 3 out of my 5 favorite mishaps to talk with members about. This morning, we're going to talk about mishap number 1, which is using out-of-date compliance policies or tools. We're going to talk about the handbook. We're going to talk about job descriptions, one of my most favorite things to talk about. We're going to talk about personnel files. Then we're going to talk about mishap number 2 today, which is a poor recruitment process. So we're going to talk about the importance of recruitment. Then we are going to talk about mishap number 3, which is not administering appropriate leave laws. That is what we're going to cover today. Next Thursday, we will talk about documentation and discipline, and then we will talk about employment laws. So hopefully today we will have enough room for questions at the end, because when we talk about leave laws right now under COVID, there's a few things that have changed, especially when we talk about the size of a member. For instance, if you're under 50 and you're not following FLMA, well, right now there is one little thing about FLMA that you are following. So I am working off my laptop only, not in my big screen. So I am trying to pay attention to people who have questions. I have to maneuver around a little bit. Somebody already said hello. Yes, we'll be sending to everyone the recording. Okay, very good. So I have to click those out and click back in. So sorry for that. This is just the way this is going to work. I came to the Salem office to do this, and in the back you see we have cabinets with red marks over everything, which means don't touch. So anyway, we're all making this work in a very unique way. So first of all, is the volume okay? Can you all hear me? Those that I can see that have thumbs up, excellent. All right, so here we go. Okay, let's see. A little technical difficulty already. Why is my slide not going forward? Whoops. Okay, off we go. Like I say, there's always something. All right, part 1. Mishap number 1, using out of compliance HR tools, handbooks, job descriptions, and personnel files. Let's talk about the employee handbook. You know, it really has been since 2016 that we've really had to have a handbook. Many of us have had handbooks through the years, but we would update them, I don't know, every 5 years or so, maybe not even every 5 years. And so now, since really 2016, since certain policies have to be in your handbook, we're constantly updating this. And for those of you that have a lot on your plate, you wear many hats, you have HR plus other things, or even just HR, which is a big job in itself, you know, where have you updated your handbook? And you're like, yeah, I just did that. Well, then we go to look at the handbook. Well, you did it 7 years ago, but it seems like you just did it because it is a huge task. So, as you know, CIS has the HR toolbox, and in our HR toolbox are tons of policies, procedures, samples for you to grab. Every year, Tamara Jones updates the CIS sample handbook. The 2020 version is in there. And so what I really think might be a good idea is if you just put that on your tickle file, that every January, kind of like every year you start your budget process, every year you do other things, start putting it on your calendar, that every January you go into the CIS toolbox, take a look at the handbook. We're now putting in that handbook what has changed. So you know that you are putting in your handbook some of the most up-to-date legal requirements. So, okay, I have boxes all over my screen here. All right, so in this handbook, we want you to have a front page that talks about the fact that the handbook is not an employment contract, all right? And that nothing in this handbook creates an employment contract. We also want to make sure that we are dating our revisions. This gets really important when you go to discipline an employee or you're referencing a policy or procedure that maybe an employee is being disciplined for, and you say, well, here's what it says in the handbook, and then the employee brings their version out and say, well, this is the one I have, and you're like, oh, we updated it, and the employee says, didn't get it. So always date our handbooks, have a clause in here that says this revision can be updated anytime and it supersedes any other revisions. And then make sure when you update your handbook that a copy goes out to all of your employees. We also want in a handbook a signature at the back that says, I received this handbook and I had an opportunity to speak to a supervisor about any of its contents. And again, in our sample handbook that we have in the toolbox, we have samples of what that might look like. We also want to make sure that this is an at-will employment unless there's a CBA, which we usually have a clause in the handbook that addresses that as well. Okay, why again? Am I not going anywhere? It's not moving along. Oops, sorry about this, you guys. This is just kind of freezing up on me. Okay. Sorry. Okay, certain policies that we want in the handbook is the non-discrimination and retaliation policy, an updated harassment policy, the new law is of January 1st, 2020, and the new January 1st, 2020 accommodation for pregnant employees law. We're going to talk about these laws next week when we talk about employment laws, but these are ones specifically that you need to have updated and in your handbook. Other things we want you to have is the sick leave law. Again, Oregon sick leave law is of January 1st, 2016. This is one of the first laws that Oregon said must be in a handbook. So it was really since 2016 that you now actually have to have an employee handbook. Before that, it was kind of a best practice. We again will talk about this law a little bit later today. FLMA, OFLA, if applicable for you, for your size, we'll talk about this later today, or if not, what are your leave laws? Drug and alcohol. This is an important policy to have. Since especially the passive recreational marijuana, what is your entity's policy on drugs? Do you have a no impairment policy or do you have a zero tolerance policy? This is not a given. And when you hire an employee needs to know what your entity's policy is because not all of our entities are the same. So for a lot of the handbook, it's called an employee handbook because we're really trying to set our employees up for success. What are the rules in our organization? Your organization is not the same as another organization. So you may have hired someone from another public entity, but you may operate completely different from the organization that they came from. Social media, cell phone, and tablet policy. This is important to have. Many of us give our employees tools to do their jobs, and some of those tools are a cell phone. Some of those tools is a tablet. What are the rules and the policies? We've had many employees get in trouble by taking personal pictures on their entity cell phone. Sometimes personal pictures have been very, very inappropriate. And then, you know, we're in maybe a different kind of a claim, maybe a sexual harassment claim, and they've taken them on their city phones. So what is your policy? When you give these tools to the employee, what is the expectation? Don't assume that they know. Okay, another thing to talk about. For the employee, what's call-in procedures? What does that look like? When are rest breaks, lunch breaks? What's my work schedule? What does the attendance policy look like? Many of us are working from home. Have you given your employees some kind of a telecommuting policy? So perhaps your attendance policy in your handbook is for when you're in the office, but maybe you have written a telecommute policy right now for employees who still may be working from home. What does your progressive discipline look like? This is something that a lot of members just say, oh, we have progressive discipline. But if I'm an employee, I might want to know what that looks like. So even though certain circumstances change, your policy might say something like verbal, written, an employee could be put on leave of absence pending an investigation or before termination. But something, not that every time it goes this way, but an employee should know what might that entail, all right? Hours of work. Callin procedures. Callin procedures, actually, I look at a lot of handbooks, and this is one of those that I think we forget about when we go in to update our handbooks. We're so concentrated on laws, we sometimes just skip over certain policies that we've had for like a long time. So I was reading a handbook not very long ago that said the call-in procedure was to call the manager 3 hours before the start of the day. Okay. So I was talking to this manager and he said, I don't want them calling me at 2 o'clock or 3 o'clock or 4 o'clock in the morning. He goes, I said, but look what your handbook says. He's like, oh yeah. He says, well, now I just tell everybody, just give me a text. Okay, then let's look at what that policy says. If your policy is call-in procedures will be by department, great. Then departments, what are your call-in procedures? Let's make sure when our employees come to work, they know what that is so that you are not disciplining them later for not following your procedures, or the fact that your procedures have changed and the employee is looking at the call-in procedures and saying, well, I called you at 3 o'clock in the morning and the manager's all mad now, okay? So again, part of this is helping our employees set up for success. Okay, next documents are personnel files. Where do we put what? And many of you have heard me talk about this over and over again, but again, we're finding certain documents that are just all being thrown together. Let's talk about the first one, the I-9 binder. So when you do an employee's I-9, yes, you actually have to fill it all the way out, even though it's your entity and you're like, I know my address. Well, you need to fill it out completely as well as the employee. All right, you're going to take that I-9 and put it in a binder or a file where things won't fall out. So a binder is a great idea. You're going to put it in by alpha. So it's the employee's last name. You're going to have an active binder. These are all my active employees. When an employee leaves, you're going to put it in your inactive binder. This binder needs to be placed in a confidential area because these forms have protected information on them. They may have the employee's social security number or passport, whatever documentation your employee gave you for the verification, all contains protected information. So we want to make sure this binder is locked, maybe in a drawer or in an office, somewhere where no employee can just walk in, open it up, and take a look. But someplace that who is ever in charge of this binder can get it just in case you are audited. All right, so no I-9s in the personnel file. Oh, hang on. We've got a chat question. A binder is for physical keeping. Is it okay to keep only electronic binder? Yeah, many people are going to electronic processes for everything. People are going paperless. That is fine. But I would say that again, electronic binder needs to be able to lock down. So probably a password to get into it so that, again, not anybody can get into that file. I understand we're going paperless and we're doing all of this on the computer. So when I'm talking about files, think of the file. Think about if you're doing it electronically, think about password protection. How, again, am I going to keep this information confidential from those who should not be seeing it? All right, personnel files. So what goes in the personnel file? This is the employment file, right? So you're going to put your employment application in there, okay? This came from the recruitment process. We'll talk about it in a minute, but this is the one document from the employment for the recruitment process that's going to go into the employee's file. Perhaps also if you did a conditional offer letter, which we're going to talk about recruitment, which I'm hoping you are all doing conditional offer letters. We'll talk about that pretty soon, okay? You want to put any other documents about the employee at work. So any forms, handbook forms, performance evaluations, disciplines, as well as kudos, promotions, transfers, PAFs, anything about the employee in the state of their work, certifications of training, all of that is the personnel file. This is the file that is discoverable. So when we say, I need to see the employee's personnel file, the manager comes down and says, I'd like to see the personnel file. This is the file. There is no protected information about an employee in a personnel file. This is very different from years ago when our personnel files were so thick sometimes that you had to have two hands to take them out of the cabinet. Now we're going to have multiple files for an employee. So this personnel file is the one that is discoverable. So when we're thinking about what goes in this file, I'm frozen up again. Oh gosh, I'm so sorry, you guys. I don't know why this keeps freezing up. The personnel file versus maybe a benefit or a payroll file, this is the file that's going to have the protected information. So W-4 forms, direct deposit, benefit information, deferred compensation, anything that the employee has given to you that has personal stuff. So their Social Security, date of birth for any of their family members, Social Security numbers for any of their family members. So what I tell employers all the time is take your employee and split them in half. Personnel is about work, job description, certificates of training. Our confidential file is files that have personal information about the employee specifics, their direct deposit, okay? So personnel file, personal file, confidential file. This is the file that is not discoverable, all right? I called this one a benefit payroll file. You can just call it a confidential file, all right? Another confidential file that is not discoverable might be a file that has medical information in it or workers' compensation information in it. If you are large enough to follow FLMA OFLA paperwork, that's going to go into a medical file. This again is a confidential file, not a file that is discoverable. All right, so this is where we're going to put maybe an employee is coming back from any kind of a medical leave and they have a doctor's note. It's going to go in a medical file. I have found for some very small members, they don't want both a payroll benefit file and a medical file because they're so small, or they want to put medical in with workers' comp. You know, that's fine as long as you are identifying it as a confidential file. Again, some members say, I'm going to have my payroll benefit stuff, and then I'm going to have all medical put together. Perfectly fine, okay, perfectly fine. Looks like there's a little, hang on, sorry, in the chat box. Let's see what the question is. Where do criminal backgrounds go? Oh, stay tuned. Recruitment. Okay, so you've done a recruitment and now you have all of this recruitment information as well as background information, all right? So everything from a recruitment is going to come to HR, all of the job postings, all the applications and resumes of people who applied. We're going to put that all together. The applicant, your final applicant that you are giving a conditional offer letter to, and you are going to do a background on, you're going to take the employment application, you're going to put that over into their personnel file if they actually pass their background and become your employee. But the other specific information about this final candidate, their resume, their letters of recommendations, their reference checks, if they are a safety sensitive position, you are going to do a pre-employment drug test. Maybe for all of your employees, you're doing a DMV and a criminal. This information is going to come together. You're going to put it in a sealed envelope. Okay, depending again on your organization, some people will file this sealed envelope in the HR office. Some people don't have that much room, so they will put the sealed envelope on top of their all the rest of their recruitment information from that recruitment, and write confidential or write the recruitment date and put it in their file room for when we will then be able to later expunge those records. So put it in a sealed envelope. I used to put that envelope in my HR office, okay? But what I needed to remember is for certain recruitments, I'm going to remove that envelope when I get rid of that recruitment based on what the retention records say. For police, that's going to be a little bit different. We are going to keep that file a little bit longer. So I used to have one cabinet for police where I kept that, and then I had my other employees. So that's all going to go into an envelope, and you are going to seal it. Let's see. Here we are again. We're all caught up. Okay, how long do I keep everything? Go out to the Oregon Administrative Rules, ORS. For those of you who are city recorders, you live on this page probably, or you have it memorized. But go out to the ORS, the Archives Division, Chapter 166. If you are a county or a special district, you're going to go to Division 150. If you're city or municipal, you're going to go to 200. And then I've queued up a little bit as to what subsection you're going to go to. When I was in HR, I visited this all the time to make sure nothing had changed in the ORS as far as which document, how long I keep everything. Some of these documents that you're putting in your personnel files may be separated out. So again, you have to really pay attention to what is the document, what is the category, not what is in the, what file it is. I'm sorry, this is clicking too fast and there's a chat and I'm trying to find where it is. Can you repeat what documents go into the discoverable personnel file? Yes. Everything about the employee being an employee, which is going to be the employment application, job description, training certificates, kudos, discipline, PAFs, anything about changing in the organization, salary increases, a vacation, maybe you've been there for so many years and your vacation goes up. So everything about the employee. Salary, let's talk about salary just a minute. Salary is discoverable, but payroll records may not be, because payroll records may have personal information on it. So that's why the payroll records are going to go into the payroll file. But what an employee makes as far as salary is public. All right. Why does it have to be sealed? Because again, you're collecting confidential information when you're doing that background. When you fill out the form that says, we're going to do a criminal on you, most likely that final candidate had to give you their social security number in order to do that background. If you're going to do their DMV check, you're going to have to get personal information about their DMV. What's their Oregon driver's license number, for instance. So that is going to have, again, protected information. So always kind of balance. Does this document have personal information? Yes, I probably need to seal it and make sure it's confidential. And I'm frozen again. Okay, let's move on. If you have questions about that, hopefully we'll have time at the end. If not, for those of you, I will have my contact information and you go ahead and email me and we'll take care of you. So using an old job description. Job descriptions are funny things. We use them in so many ways, yet I constantly talk to members and I said, do you have an updated job description? Because we're talking about a situation and it's like, well, they're kind of old. Well, the employee has been here for so long, so we've never had to update their job description. Well, we use job descriptions for many different things. We use job descriptions for recruitments, but we also use job descriptions for performance management. We should be using job descriptions when we sit down to do our performance evaluation. That is a great time to get that job description up to date. Manager and employees meeting, say, let's go over your job description. Let's revisit the essential functions. Let's revisit what this job does. Maybe that's the tool we use when we go to discipline. This is actually one mishap that managers run into. They want to discipline an employee, and then we go to look at their job description, and there's nothing about this essential function or the category in the job description. At some point it morphed, but we never came back and sealed it with the employee. So how do we hold an employee accountable to do their jobs, or at least to meet the categories of their essential functions, if we never updated the job description, if we never told them what it was? So we use it for discipline, we use it for coaching, we use it in performance evaluation, we use it for pay equity. Okay, we're going to talk about the anatomy in just a minute of what should be on a job description. We use it for workers' compensation, right? We use it for return to work. Are we going to reasonably accommodate this employee? Well, what are we accommodating? So there are reasons why we should keep our job descriptions up to date. So now let's talk a little bit about the anatomy. What should be on your job description? Well, of course, we wanted to talk about what the title of the job is and what department this job is reporting to. I like to see the FLSA status. An applicant as well as an employee should know, am I exempt or non-exempt, all right? We also want to be clear about if this position is represented or not represented. If it's represented, I like to actually put on there what is the organization. Is it ASME, police association, so SEIU, so who is the represented party? Pay grade. This helps us with pay equity. It lets us know that this position is grade 22. Excellent, all right? So when we are hiring, somebody's not saying, well, I want grade 24. No, this is grade 22. Of course, the purpose of the position and the essential functions. Now, we don't put on a job description every single thing, every single task, but we do put the categories, all right? And this, again, is going to be a tool to help the employee know everything I'm supposed to do as far as essential functions, and the manager as well. Okay, we might also put on their occasional job functions. So an employee may be charged with backing up someone. So maybe an occasional job function for an employee is to back up the receptionist for breaks or lunches. We want to put that on there, okay? Because again, this is something the employee should know, oh, this is going to be part of my job. Maybe not something I do every day, but something that I am going to have to do as part of my job. Let's see, we have a couple questions. Sorry, where did my bar go? Oh, fine. There we are. Other duties as assigned has always been a standard phrase. Is that still okay? Sure. I think that is fine as well. Sometimes people say, well, what does that mean? So if I'm an applicant or after I've been hired and we're going over the job description and somebody says, can you kind of help me out with what that might be? Because I want to make sure I'm qualified. So when we say other duties as assigned, we are expecting that if we ask an employee to help out with something, it is something that they are qualified to do. Okay, so if you have a public works employee and you say, hey, I want you to go down and take care of some at the wastewater treatment plant, and the employee goes, I don't have an operator's license, well, we're not going to send them down there just because they work in public works. So make sure your other duties as assigned is actually duties that they are qualified to do. Other things we want to identify, KSAs. This is very popular, knowledge, skills, and abilities. Again, it's another way of helping to define an employee in this position should have this kind of knowledge or this skill or this ability in order to execute parts of the job, all right? Core competencies. This is something that we've been doing, I'd say probably the last 10, 15 years. Very popular in the private sector. I think it's gaining traction in the last 10 years in the public sector. Here's how this can really help you. A competency might be what an employee should be able, how an employee should be able to execute, how they go about. For instance, flexibility. Does this position require an employee to be flexible? Good time management skills, teamwork, problem solving, customer service, attention to detail. These are some examples of core competencies you might want to put in the job descriptions. Of course, you're going to put in ones that are applicable. But when we get to interviewing, we're going to talk about this on how you can use core competencies to help you in interviewing. But it also comes back to the fact that when an employee reads their job description or an applicant reads the job description, they understand what are some of the skills that are going to help them be successful. So if you're like, this job needs to be able to be flexible, and this applicant is like, I don't like things flexible, I like things rigid. Well, they may not be successful because maybe they have to balance many things. So core competencies is just one more tool that helps us put on paper, okay, what an applicant may need in order to be successful. Always great to have supervisor responsibility. Somebody should know, am I going to be a supervisor? Who am I supervising? Or this job is going to be supervising these people. Nature of work, physical requirements, minimum and special and preferred qualifications. I still see a lot of job descriptions where we've bunched all of this together. That can be difficult when we are going to actually assess an applicant against the job description to see if they're qualified. So when we're doing it in recruitment. So minimum and special qualifications, what does this mean? I like to look at minimum qualifications as this is what you need walking in the door, okay? This is what we have decided an applicant needs to be successful day one. Now, an applicant may need to learn everything about our organization specifically, but what I need is maybe X amount of experience or degrees. So this is what I need coming in. Special requirements might need driver's license or certain certifications, either that I need to have coming in the door or maybe I get in the first 30 days, 60 days, 6 months. Preferred qualifications you don't have to have, but it sure would be great to have, all right? So if I'm hiring an accountant, I might say, boy, it would really be great if they were a CPA. Don't need it to do the job, but something that would be very, very helpful. Okay, I can see I am talking too long because we are already at 10:30. All right, let's get into poor recruitment process. If there's some chats, I will come back to those, all right? Poor recruitment process. This is one of the most important things that you will do as a manager or as someone in your organization responsible for bringing people in. Spending time doing a very well thought out recruitment process. I know we get challenged. I know we get, I need somebody right now, somebody hopefully with a pulse. Let's get them in the seat. We got a lot of work to do. Hurry, 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 get me somebody. And you're like, okay, we're going as fast as we can. But we don't take the time to do it well. We hire someone and then, gosh, 6 months later, that person's not working out because we really didn't take the time to put together what we need. So up front, let's define our process. Let's take a look at that job description. Let's look at our application, make sure it's up to date. Let's create and post our recruitment posting. Let's put together our application and our interviewing scoring sheets. Let's have a sample conditional offer letter ready to go. Let's identify what our background process is going to be, all right? So that employment application, I think we all know, laws have helped us update this, right? We have no Social Security numbers, date of birth, no year somebody graduated, okay? That kind of leads to age. No criminal history. We had banned the box of January of 2016, which says you may not ask about criminal history in the initial stage of the application process. We no longer have salaries. That was the 2017 Oregon Equal Pay Act. So none of that information on the actual application, okay? We have a whole training on veterans preference. I'm not going to go into this deep, but what's very helpful is to go ahead and attach a veterans preference application to your entity's application. Just put it right on there. And we have a sample in our toolbox if you don't have one. But the Oregon law says, hey, if you have a veteran that meets minimum qualifications, and if they meet certain criteria under the veterans preference, which means when they put their application forward, they're going to give you certain documentation to help qualify them, which is either the DD 214 or 15. If they meet minimum qualifications and or special qualifications, they may be moving forward in the interview process. We want to make sure that we have given that information right up front to help them with that application process. So again, sample is out in our toolbox. So creating that posting, how are we relaying to the public what our posting is all about, what this job is about? So here is information I like to see in the posting. One thing that I see people miss is what background is going to be required. Best to put that right up front so your applicants know, oh, I'm going to go through a background process. Oh, they're actually going to check my criminal. Oh, this is a safety sensitive position. I'm going to have to do a pre-employment drug test, or they're going to check my DMV. You know, just put that right in your posting so your applicants know, all right? Also make sure you're very clear with how to apply and what they need to submit. Here is a sample application scoring tool. This is out in our toolbox. This is a sample that I've been using my whole HR career. I've used it when I was in nonprofit, private sector. I used it in the public sector. I've used a version of this through the years. It helps me. I'm moving an applicant forward, because this is something you can get challenged on, especially if it's a veteran and you didn't move the veteran forward. Somebody's going to call and say, hey, I want to know, I applied for your job. I want to know why I didn't get an interview. And then you have to go back to your pile, pull their resume or their application out and go, oh, I'm trying to reread it quickly and find out why. If you have this tool attached, you can do it electronically or in paper, to each application you reviewed, you have right on here why they moved forward or why they did not move forward. Then you are not having to second guess yourself later. Okay, the interview process. Why are we interviewing? We want to learn. We want to know about the applicant's knowledge. We want to know about technical skills, and we want to know about interpersonal skills. Here's where that core competencies are coming in. We want to know if they're a team player. We want to know if they can be flexible. So again, so many times members call us and say, I hired this person 6 months ago. They're not working out. I don't know why. You know, they have the degree. Well, we always look at that technical stuff. Well, did we ask any questions about how they work with others? Well, no, you know, we were just great resume. They have the degree we wanted. Well, let's talk about other things. Let's ask those soft skill questions in our interview, because again, you only want to do this once. Questions you should not be asking, well, we know a lot of these. You can't ask certain questions about personal information such as marital status, age, religion. But here's a question I see time and time. People like to do the icebreaker, and their first question is, tell me about yourself. Well, I'm the candidate. I'm a little nervous. What am I going to do? I'm going to start telling you about myself, and I might give you information that's personal. So maybe your icebreaker instead of that is, tell me about your education and your experience as it relates to this job. Okay, now as an applicant, I can cue right into, oh, you want to know about me as it relates to the job, which is how my education and experience is going to be applicable. That's going to keep you away from the tell me about yourself, and they start telling you, well, I'm married with 3 kids, blah, 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 blah. I can't use any of that information. Okay. Scoring the interview. I like to keep it simple. I use 10, 5, 1, and 0. I don't give points to an applicant just because they talked. If they didn't answer the question, why am I giving them points? The thing about whatever schedule you create is to test drive your scoring and your interview questions with your interview team. When we look at scoring, have a definition, talk to your team about what does this mean? What does a 10 mean? What are we looking for? What does a 5 mean? What does a 1 mean? So identifying it and talking about it. I'm very big on training our interview panel. Do not put this group together the day before your interview. Set the team up, bring them in before the interviews, give them the questions, give them the rating. Let's talk about the rating. Let's talk about the questions. What are we looking for in our answers? This helps your interview team be a little bit more on point on what are we looking for, all right? Otherwise, we kind of wing it. We come in the day of the interview, we sit down, we look at the question that we're going to ask because we went around the room and we counted heads, and you're practicing the question you're going to answer or you're going to ask. Well, we need to do that a couple of days in advance, all right? Let's make sure we give a conditional job offer to the final candidate. This offer says, here's what I'm offering you in salary and benefits. It's contingent on you passing the background, all right? And the background is included in this. Here's the form I need you to fill out to give me the information so we can go forward and do this. So very important to do a conditional offer letter. You know, many people said, oh, I just do this by phone. Okay, well, what if the applicant comes back later and says, that's not what I thought we agreed to? Let's get it in writing. All right, I've got 20 minutes left. Let's get into administrative leave laws, and then I'll come back and pick up the questions that are in the chat box. I tend to get a little chatty, so sorry about that. All right, not administering appropriate leave laws. Oregon sick leave. Well, we know that this occurred in January of 2016. It was the first policy that Oregon law said must be in your employee handbook. So all of us must be following this Oregon law. If you are an employer of 1 to 9 employees, your leave is not paid. If you're an employer of 10 or more, your leave is paid. All employees, even your regular, your part-time, your seasonal, and your on-call employees receive this leave. But how are we calculating is what may be different. You accrue 1 hour for every 30 hours worked. It accrues from the first day of employment, but you get to use it on day 91. So even though you may have a seasonal employee that works for you for 60 days, you're still calculating that, but they're probably gone before they use it. However, if you bring them back 4 months from now, you're pulling that bank back up. Any specific questions about that, we can tackle later. But the employee may start using it at day 91, all right? 40 hours is what the law says an employee must accrue. Many of you accrue more than that, which is perfectly fine to do more than what the law allows. How can I use sick leave under this law? Well, an employee can use it for their own physical or mental illness, for a diagnosis, care for a family member. The purposes are specific or addressed in the ORS. But basically, an employee may use it for themselves or a family member, all right? Now, I get oftentimes employers coming and saying, hey, what about sick leave abuse? Can we still tackle that under this law? Yes, you may. You may still have a sick leave abuse policy. All right. Now, remember, an employee has a minimum of 40 hours that they get to use under this law, which means you cannot retaliate or discipline an employee for using their leave. All right. But if you feel that they are using the leave inappropriately or against the sick leave policy, we can talk about that. So if you think there is an employee abusing the sick leave policy at all, go ahead and give us a call and we can help talk you through that. But again, the law says you may not retaliate against an employee for using the leave. Okay. FLMA, OFLA, ADA, or if you are an employer not large enough for FLMA, OFLA, what does your leave law in your handbook or your policy say? So the basics are, we have ADA and disability law. We're going to talk about that in a minute. If you have 6 or more employees, you must follow the Oregon disability law. If you have 15 or more, you're following the ADA. Under FLMA and OFLA, if you have 25 or more employees, you're following the Oregon Family Leave Act. If you have 50 or more, you are following both laws, not just one. I often see employers still only have the federal forms and they say, well, since we're over 50, we're just going to use the federal forms. Well, what we have to remember is Oregon and federal is not an exact match. We're going to talk about that in just a minute. So you must administer both laws if you are over 50 employees. As you know, we have 12 months of employees under both laws. We get the laws under different times. Federal, 12 months. Oregon, 180 days. 1,250 hours for federal. Average of 25 hours for Oregon. Both are on an average of 12 weeks a year, although we know some laws have some stacking. I know that there's some questions and I'm going to come back to you, okay? Very important. This is an area that many members goof up on because, again, they're just concentrating maybe on the FLMA. Well, if you're doing that, you may not be extending all of the family members that are covered under OFLA, all right? Or vice versa. Okay, so FLMA only has child, spouse, same gender, domestic partner, and parent. OFLA, child, spouse, parent, grandparent, parent-in-law, grandchild. So there are more categories. An employee may go out under OFLA to care for a grandchild or a grandparent or a parent-in-law, they still have all their federal left, okay? So that is one reason why we must track both. Out in our toolbox, we have forms to help you. We have already identified forms with both laws, if you are both FLMA and OFLA, or just OFLA. So go out to our toolbox, grab our forms, and they will help with categories as well. Okay, why can we go out for FLMA OFLA? Well, we can go out for our employee's own serious health condition of a family member. There's also pregnancy and parental leave, all right? This again is where we get into the category that, especially under OFLA, an employee may get more than 12 weeks in a year, okay? These policies must be in your handbook. If you are not FLMA or OFLA, what is your leave policy for an employee perhaps going out on a serious health condition? Have you defined that? Have you defined what a serious health condition is going to be? Have you defined how long an employee can be out? Is it only as long as they have time on the banks? Do you have medical leave sharing policy? So what are your policies in your handbook that you have around an employee going out on some kind of medical leave? If you haven't taken a look at that policy lately, take a look, and if you have questions, give us a call and we can help you step through it. Oregon, as we know, has the sick child leave policy. So this is, boy, my child doesn't have a serious health condition, but has 100 fever and he can't go to daycare or can't go to school. Oregon says, employer, you must allow your employee to stay home under the Oregon sick child leave category for a non-serious health condition. Now, what is excluded is because school is out or daycare. All right now under COVID, that blew up. We'll talk about that in a minute because this is exactly why people are staying home in certain categories. But under the regular sick child leave OFLA law before COVID and maybe after COVID is not because the babysitter can't come for the day or you're going to a medical or a dental appointment. That is not under sick child leave, all right? All right, one thing, a mishap that happens over and over again is the employer not giving the paperwork to the employee who has asked for leave on time. And that is because sometimes whoever is in charge of this leave doesn't know. Nobody told HR or the person in charge of administering leave that an employee actually needs leave. So this is where we need to educate our supervisors about this. So, first step is we learn that an employee needs leave, and employee may not use the magic words. So they might just say, hey, you know, my wife's gonna have surgery one of these days. Oh, red light, go talk to HR, and HR can talk to you about that, all right? HR, you've got 5 days to get these forms out to the employee once the employer learned about the leave, not once HR finds out, but once the employer. So that might be the supervisor, okay? Employee has about 15 days to get their paperwork back, and then HR, when you get that, you've got 5 days to make a decision. Now, I just helped a member where their employee had a stroke and she was in the hospital. She was not coherent. Actually, she was in coma. Well, her daughter was helping with communication. Well, the entity kept giving the daughter the paperwork to have it filled out. This daughter had so much on her plate, the paperwork never came back. So the member said, what do? I didn't get the paperwork. You know what? Go ahead and qualify it. We know where this employee is. We know this employee is in a serious health condition. So in that case, I said, go ahead and qualify it and begin the documentation that says, here is what you have for FLMA OFLA coverage. Here's your 12 weeks. I said, make sure a copy goes to the home address as well as to the daughter, so she is on top of this as well. So sometimes we use a family member to help with the communication. Intermittent leave. This is a hard category sometimes for our members to keep track of. This is when an employee maybe has a serious health condition or they need intermittent leave. Maybe they need to go to physical therapy. Maybe they're going for cancer treatments. Maybe they have a serious health condition such as I don't know, ulcerative colitis or something, where they're calling in sick different days, or migraines. These are all categories where an employee's not out for a block of time, but they might be gone here and there. This can get frustrating for some managers. The employee called in sick again, you know, oh, but they called in sick and it's under the category of a serious health condition. We need to make sure we are tracking this. So intermittent leave is hard to track. If you need some help with that, go ahead and give us a call, because this is one of the big mishaps in tracking leave that employees oftentimes mess up on. Sorry. Okay, ADA, we have Oregon and we have federal. 6 or more or 15 or more. What does this say? This says employer, if you have an employee who needs a reasonable accommodation in order to do the essential functions of their job, you need to take a look at this. All right. And so these reasonable accommodations for a disability, the disability may be an impairment, it may be perceived or not. Okay, sometimes people say, I have a disability. You're like, I don't see your disability. No, but whatever disability they have, they need a reasonable accommodation. We may enter into the interactive process with the employee by employee saying, I need some help. You're saying, I would like some medical information to help us identify how to help you better. So employer, we're not second guessing. We are not doctors. We have the right to ask for medical information to support the reasonable accommodation. This again is where that job description might come in handy, or maybe you've even done a job analysis, which is something a little bit more detailed about the job. This is where we can give this to the doctor and say, help us help our employee. How are we going to do this reasonable accommodation? Then we want to sit down with the employee. We want to talk about it. Oftentimes employees come up with the best scenarios of how to accommodate them. This is where that job description about essential functions versus non-essential functions comes in very handy. We do not need to reasonably accommodate non-essential functions. So those occasional duties, okay, we do not have to reasonably accommodate those. What we are reasonably accommodating are their essential functions of their job. So what the reason for the job. Again, reason to have an updated job description, all right? We're gonna pull that document out. Let's go through it with the employee. These are your essential functions. Which ones are you having a hard time with? Which ones do we need to do a reasonable accommodation? Let's talk about the reasonable accommodations. The employer, you are deciding at the end, all right? The employee doesn't get to say, I want this and this and this, and you have to do it. You're going to look to see if the accommodation request is going to be reasonable, all right? So here's our questions. What limitations are you experiencing? You're going to sit down and have this conversation. How are these limitations affecting? What specific tasks? Have you tried anything to help with the limitations, okay? So this helps you guide through the conversation. One of the biggest mishaps is informal accommodations. Oh, we'll just try something for a while and see how it goes. And then we never circle back. Well, now you've done it. Maybe we went ahead and took out some essential functions out of the job description to try it. Well, I think you just created a new job description, because the law does not say you have to take essential functions out. So if you start doing that, you now gave that employee a new job description. So again, be very careful with how we are altering. What does that conversation look like to make sure we are keeping that job intact, and we're looking at, again, how do we help them? All right, now, sorry, I'm going kind of fast. I'm going to try, goodness sakes, try to get up back up to this bar. Oh, for goodness sakes. There we are. All right, let's find our chats. Let's go all the way up. Okay, we answered that one. I've been involved with an ongoing employment workers' comp issue for the last year, where I've accumulated notes from phone calls with attorneys, correspondence with attorneys and the employee, etc. Where does all this stuff go? I've been keeping a separate management file for this, but not sure if that's correct. I would put it in the work comp file. That's a confidential file. Is there a PowerPoint available for this? Absolutely. Anybody who wants this We will make this PowerPoint available to you probably at the end of next week because, as you can see, I already clicked forward. It's all inclusive. Doesn't FLMA apply to all public agency regardless of the number of employees? Yes, but no. Yes, federal law says you must put the poster up. It's applicable to everyone, but in order for the employee to have the benefit of FLMA, you have to be an employer of 50 or more, not counting what's going on right now with COVID. As you know, with COVID right now, we have the Families First Act, which all employers, especially all public employers, that's what I should say, for public sector, must be following. But if you have less than 50, your employees actually don't get the job protection. But yes, you still must post the posters. Kind of one of those interesting things. Donna, I think that is the case for the new, okay. Well, somebody answered somebody. Okay. It says, Donna, I think that is the case for the new, yes, regarding COVID with regular FLMA. I understand that there's 50 employees with, yes. Very good. Okay, so let's take just a minute to talk about that. For your members that have under 50 employees and you never followed FLMA before, yes, now during the Families First, you must give job protection to employees under certain categories, all right? If you are a FLMA provider already, these fall under the 12 weeks. So if you have an employee who has already used their federal 12 weeks, let's say in January, February, and March, they were out for surgery, and they've used their 12 weeks, they don't get an additional 12 weeks under COVID, okay? So if you are a FLMA provider and your employee has already used their 12 weeks or has started to use their 12 weeks, if they are using leave under COVID, it is the balance of that 12 weeks for whatever your 12-month cycle is, whether your calendar, look back, etc. Okay, so again, the categories that we have under COVID is 80 hours under an employee who has been advised by a healthcare provider to self-quarantine, the employee is experiencing symptoms and seeking a medical diagnosis, and an employee is caring for an individual who has been told to quarantine. Then we get in the child care component, which is an employee is caring for a son or daughter because school or daycare is out. And then, of course, item 1 and 6 really isn't playing right now, but number 6 is the employee is experiencing any other substantially similar condition specified by AHS that's not been identified. So for most of our members, they are following under categories 2, 3, 4, and 5. Under OFLA, when we started to talk about the non-serious sick leave, and I said it doesn't apply for school or daycare. Well, under COVID, Oregon said, and this actually sunsets on September 13th, 2020, we'll see if they expand it, but that said, oh, if an employer's employee's child is out because of school or daycare, we are giving them OFLA leave. So that, though, again, like I say, is sunsetting on, at this time, September 13th. We are at 10:59. I'm going to see if there is another question. I'm not seeing one. All right, we're at 11 o'clock. If there's no other questions, I'm going to be told to sign off. So you have my information. Sharon Harris, well, I don't know where my slide went. sharris@cisoregon.org, or give me a call at 503-763-3843. If not, next week we will chat. If you have any other questions actually about this one, maybe we can even grab it next week. So we're going to be talking again next week about discipline and about leave laws. So if you think of a question, say, oh, I forgot to ask that. Hey, let's pick it up next week, okay? Have a great week. We will talk to you again. Bye.